Hello, and welcome to Law Talk. My name is John Celebrezze, and I'm the co-founder of the Celebrezze-Zange Community Legal Education Project, as we call it, CZ-CLEP for short. Our organization provides continuing education about the judiciary and legislature to attorneys, judges, government officials, and the general public. As a career educator, I recognize early on how important legal matters are and how they impact our lives. I am the nephew of the late Anthony J. Celebrezze, who was the popular 5-term mayor of Cleveland and a member of President Kennedy's cabinets. As a tribute to his lifetime commitment to the legal process, we dedicate this show.
Today's John's guest is J. Bruce Francis Esquire. He received his BS.BA at Xavier University and his Juris Doctorate at the University of Detroit. His area of practice is civil mediation in the Medina County Police Court for the past 11 years. He's a member of the OSBA Banking, Commercial, and Bankruptcy Law Committee and the OSBA Dispute Resolution Committee. His continuing legal education contributions have been post-judgment remedies, mediation procedures and process, and what's new in dispute resolution. Bruce is married and is a resident of Granger Township.
Welcome to Law Talk.
Okay, John.
We're glad you had an opportunity to visit with us today. I know what you do because I visit you pretty often.
You do?
In Medina there, but for the benefit of our viewers, I don't know if everybody knows what mediation is. In fact, I'm quite sure a lot of folks don't. Even though I will tell you personally, I'm very grateful that you are there for many cases, many times. But for the benefit of our viewers, Bruce, will you explain to us what mediation is?
Yes, and that's a good place to start because sometimes people get confused. Meditation, mediation, they come knocking at the door, and I think they're disappointed sometimes when they're looking for meditation. But mediation is a third-party neutral. That would be the mediator. Meeting with people that are in some sort of conflict that are looking to resolve their differences. It's the job of the mediator to discuss their issues with them, hopefully help them to see the other side of it and see if they can work on a resolution.
So basically, albeit it seems to find its way into the court system, and of course our show is called Law Talk, and as you well know, we talk to judges and lawyers all the time. You are a lawyer, actually.
I am.
But it is not, it's not an adversary process, I take it.
Well, on the contrary, even though it's in the courts, in terms of a case has been filed in the common pleas court, which is the way it arrives at mediation, the idea is rather than fight it out in front of a judge or a jury, the participants, the litigants, and their attorneys meet with me, and we try to discuss things in a peaceful manner and try to concentrate on understanding what the other guy's side of it is and recognizing strengths and weaknesses. But
no rules of evidence, Bruce, or courtroom decorum that we're all used to?
Well, in terms of courtroom decorum, we like to think that most of the attorneys that show up advise their clients to dress for court and act appropriately. Sure. That's followed generally. From time to time, we will get some folks that come in a little more relaxed dress than you would think would be appropriate for court. But I think people, when we sit down, we try to formalize the setting to a certain extent. We come up with little name cards for them so they know where to sit.
Sure.
I address them initially, and we start with kind of a review of where they are in the court system and what's going forward. And so it is formal when they sit down, and I think that it prepares them if they're going to sit through a trial, and they're going to have to sit next to each other in front of a jury, in front of the judge, and behave themselves. So it's good practice in that regard as well.
But I guess my point in the question, though, a trial, as you well know, and the plaintiff will have to go first. He'll call his witnesses. There'll be cross-examination. The defendant will come. Pretty well, as Judge Collier always explains, 6 stages of. But We're a little less formal, though, I understanding, in the mediation session than that.
Absolutely.
And I guess I think our viewers might be interested in this too, having sat through several of your mediations. You separate people then at some point in time, don't you?
Yeah, we always start with everybody in the room together, and we introduce ourselves so that everybody knows who the parties are, who's there today, who the attorneys are, who they represent. Sometimes people will be involved in a litigation. Sometimes they'll want to bring their spouse in, even though the spouse isn't a party.
I see.
And so we encourage people that either need somebody to hold their hand a little bit, or sometimes when people are married, the spouse won't want to make a decision unless they can consult their husband or their wife.
So that's the part of the informality that actually sometimes works to the advantage of mediation. I mean,
yeah, I think so. The court, the program follows the Uniform Mediation Act that Ohio has adopted, and that really allows the parties to bring whoever they wish.
I see.
And we try to keep that sort of to a minimum, but frequently, in addition to their lawyer, they'll want to have a friend, or if it's a minor,
Sure.
an adult. So,
I've seen you do this, Bruce. When you do separate the folks, and you obviously do it very professionally, but you'll literally bring the opposing people into opposite rooms, and you go between the two.
Yes.
I.e., you are the mediator, which we're going to talk about that.
Sure.
But I guess to kind of set the stage, why are you doing that? Why did you separate them in a courtroom? You never separate the people.
Well, that's one of the differences, of course, between a court setting and a mediation. The reason that we all meet together is everybody wants to know who's there and who represents who. It may be the first time that the parties get to address each other, and sometimes it's being able to speak to the other side that they've never been able to do, and they want to get something out. So
okay.
It gives them that opportunity. The next part of it, after one party will make a demand, perhaps the other party will propose another
Sure.
resolution. We separate them so that they can speak privately, and they meet with me, and they're able to sort of express their feelings about what they heard. Well, that wasn't exactly what I thought they were going to say. They don't seem so bad. And with their attorney, they think about it, and I try to ask them to consider some things. I don't offer them opinions as to the strengths or weaknesses, but the idea is to get them to think about resolution rather than, okay, I got what I'm mad about out.
Okay.
Now let's think about how we can put this together.
Well, I will say that this idea of having the parties in different rooms and you literally being the go-between, I mean, I've seen you do that as movement back and forth for a period of hours.
Well, we set aside 3 hours on most of the civil cases, yes.
Okay,
And,
all right. Well, Bruce, we're shifting gears here just a little bit, but I mean, let's bring it on home now. I hope folks know that it's a process. The mediator is the go-between between two people. It's not quite as formal as a courtroom. We're just trying to get to a settlement, but in Medina, I think this might be really helpful. Can you describe a typical case? I know that maybe one or both of our common pleas judges would send to your office.
Sure. I could tell you in the last 3 or 4 years, a typical case has been a foreclosure. Our office handles all the foreclosures for Judge Collier, and that has become increasing large load.
It's huge.
There's just so many cases filed. But prior to that, and along with the foreclosures, we have our regular civil dockets, which consist of a lot of personal injury cases, as you might imagine.
Car accidents.
A lot of business cases.
So the bottom line is, I mean, it's of a civil nature. It's obviously not anything to do with criminal. And there are two people, and it's down to usually an amount of money that will settle this matter. Is that reasonably well said?
especially for those kinds of the business cases, the construction cases, the personal injury cases. The neighbors, it's a little different.
I see.
But
that's interesting too. I mean, a
Oh,
little
those
change of
are the-
behavior there, maybe on on both parts.
A lot of emotion on those cases.
Yeah, I never really thought about that. So you get into that as well.
Yes.
Okay, that would come to you from the court again on on the civil side?
Yes, those are cases. These aren't domestic relations cases.
Right.
These are civil cases where, you've got a neighbor next door and there's something that goes terribly wrong. It builds up usually over a series of months or even years, and it comes to the point where somebody goes and sees the attorney, and a case winds up getting filed, and the court will refer them in.
But it's a lawsuit.
It's absolutely a lawsuit,
I
yeah.
see.
From time to time, Judge Lone will refer a case as well. So we have will contests that come in.
A will contest, a probate matter, it could come your way as well.
Absolutely.
I see. So you get to see quite a variety here. I mean, I guess I most of the time I've seen you, again, using myself, it's usually been a car accident and it's been just about money, but it's not all about that.
No, not necessarily. We see quite a variety. Certainly there are the workers' comp cases, the personal injury cases where it is very much about money, but it's the full gamut. Anything that could be filed in the common pleas court, we eventually see before it goes to trial.
Is that mandatory, Bruce? I mean, is the judge pretty much telling the litigants at some point in time, I'm assigning this to mediation?
I think they both handle that a little differently. I think Judge Collier relies maybe a little more on the attorneys to tell him that they would like to go to mediation, or they think their client or the case could benefit from mediation. I think Judge Kimbler takes the position that just about any case could benefit from mediation, and so I think he's a little more generous with the time.
I see.
I think he probably refers more cases in that regard.
Okay. Well, but so there's some discretion, obviously, with the judges.
The judges and their magistrates, right?
But the name of the game is if we all turn up in your office, it's a good day at the races if you could bring us together and we have some type of an agreement when we go out of there, and hopefully that leads to the end of the case.
Yeah, there's a couple of points there. One is that people that fashion their own agreements do a lot better in keeping them, and I'm not talking about the car accident so much, but rather maybe the neighbor dispute or something like that. If the court has to listen to all the testimony and the evidence and impose some sort of resolution on them, they're less likely, I think, to be satisfied with that and to follow it. If they fashion it themselves, they feel that they own it, and they're more likely to.
Does makes perfect sense. I mean, it really has. Right. Mediation has been around for a while. I mean, it's not a new concept. I used to be the business manager of the Findlay City Schools, and when we negotiated contracts, we oftentimes relied on federal mediators to come in to assist us and bring us together when we hit impasse. But I think maybe a more local or better question to ask you here then is it simply, how did it get started in Medina County? I mean, how did it come local?